So, if you don't know me, my name is Jake Linford, and among the other things I do, I teach trademark law at Florida State. I'm going to give you basically the paper in 3 points, and then we'll just talk about it until I decide I'm done talking and I want to hear you talk. So, first of all, I think trademark law's forfeiture mechanisms, here I'm thinking specifically about abandonment through non-use and naked licensing, are too frequently ignore consumer perception and consumer confusion. I think that's inconsistent with trademark's normative foundations. I think we need to fix it. And my fixes are designed to ensure that the forfeiture mechanisms account for consumer perception of the goodwill that remains that consumers have in a forfeited mark. That's the paper in a nutshell. Now let's start talking about details. When I say the purpose of trademark law, I like Bob Bone's term, the information, now I'm forgetting the term. Gosh darn it, I'm getting old. The information transmission goal of trademark law, which is to say, what's trademark law doing? It's promoting competition through a particular mechanism, protecting consumer perception, protecting consumers from deception and confusion. We are ensuring that producers are rewarded for their investment in the manufacture and marketing of a product, in making that term work to the extent that the term signals consistent source and arguably then consistent quality. That's what I mean by trademark's goal. Now, if that's what trademark law is supposed to be doing, and if you want to argue about that, we can. If that's what trademark law is supposed to be doing, the forfeiture mechanisms are not doing that. Particularly abandonment through non-use, naked licensing, maybe to a lesser extent transferring gross to the extent that transferring gross still matters. Now, you do see genericide. I like genericide. That's my preferred term for it. I like genericide because what you get in genericide is you get a question about consumer perception. We're looking for a number. We're 50.1%, right? We're looking for a majority of consumers using a term as a generic indicator. And there's also this kind of backstop of trademark misuse. Bayer was stupid, and they used aspirin as if it were the generic designation for the product, and therefore they lose the product. I'd like to see abandonment and naked licensing work more like genericide, or at least more like modification, where we're asking the question, are we sure consumers are going to be bothered by this? Okay? That's what I want to, that's the direction I think the law needs to move to be more consistent with trademark's normative bases. And what we're doing is talking merely about how the mark owner acts. The mark owner has done things, omission or commission, that we don't like. Now the two mechanisms I'm proposing are, we may change the inquiry into forfeiture, the questions that we're asking, or maybe we change the result of the forfeiture. And I'll talk more about what I mean by that in a minute. Part of the problem with the forfeiture inquiries is statutory. When you look at the definition of abandonment in section 1127, and this is where we turn to, courts turn to for their statutory hook for this. When they talk about abandonment through non-use, this is just what the mark owner did. Didn't use the mark for 3 years, that's prima facie evidence of abandonment. No real consideration, no real language in here that talks about consumer perception. Likewise, the catch-all, and this is where naked licensing would fit, if the mark owner has done things, including acts of omission as well as commission, that cause the mark to become generic, or cause it to lose its source significance as a mark, then the mark's abandoned. Again, we say lose significance as a mark, but that statutory language isn't talking about consumer perception, it's talking about mark owner behavior. How do we see that play out? Well, we see it play out in cases like abandonment. My abandonment case is an imaginary abandonment case. How many of you used to drink Slice? That's more than I saw in a room full of 50 people a couple of months ago. Pepsi used to make Slice, or a Pepsi subsidiary, they don't anymore. It's been about 15 years. Now, abandonment presumes that once I don't use a mark for 3 years, that's prima facie evidence it's been abandoned. If I can establish before the court that I intend to pick it back up and I convince the court of that, the mark's not abandoned. Otherwise it is, you can pick it up, you can start selling the same product category under my mark. But if I see a can of Slice, what am I likely to think? I'm likely to think it comes from Pepsi. If there are enough consumers like me, what we have is a problem of residual goodwill. In other words, I have expectations you are unlikely to be able to meet because you don't have Pepsi's trade secret formula, the Slice taste that so many of us loved so long ago. That was a joke. It wasn't really that good, okay? But the new producer doesn't have the trade secret. They don't have the relationship. I'm inevitably going to be disappointed. Now, we might worry a little bit about the mark owner. I'm going to be mad at Pepsi because the product doesn't satisfy me. But consumers are going to be buying into this product. And I'm not necessarily worried about the goodwill, the free ride on the goodwill, or the windfall that comes to the new appropriator. But I am worried about the consumer confusion, the consumer deception. We also see it in naked licensing. So the naked licensing case that's the most fun for me right now is Eva's Bridal of Oak Lawn. We have a bridal store where the couple licenses a new bridal store to a cousin of one of the members of the couple. I can't remember which one it is. And they don't engage in any quality control. And when the case comes before Judge Easterbrook, you know, the licensee is now a naked licensee. He's not paying what he's supposed to be paying anymore. And Judge Easterbrook says, you didn't engage in any quality control. You lose. Because, and this is the language in a nutshell, he says, the court admits it has no idea whether or not there's some sort of common ambiance shared by the two stores, whether they behave the same or not. We're stripping the mark of its significance and we're allowing the naked licensee to kind of move forward without paying on the chance that there's inconsistent ambiance that will confuse consumers. Now note the different presumption underlying these two moves. Here the presumption is, abandonment currently presumes that when the new producer picks up a slice and starts selling me a slice, I'm not going to be confused, I'm not going to be bothered. Here, we presume that the naked licensing, my lack of quality control, is going to cause consumers to be bothered. They're completely inconsistent presumptions. And in both cases, we're ignoring what I think is a fundamental question. How do consumers see the world? I think modification gets that better. You note, modification is something that mark owners need to do from time to time. Need may be too strong a word, but it's something mark owners do all the time. And the way a modification works, a modification inquiry works is this. When I change the mark, the question courts ask is, does Mark A and Mark B, do they provide a consistent impression to consumers? Do consumers look at those two marks and think they would indicate the same products from the same source? If the answer is yes, I get to tack back to the earlier use. If no, my earlier mark's abandoned, I've got to rely on my later use. It's the right sort of question. Not that courts are taking necessarily good evidence, but they at least care how consumers see the world. I think genericide gets closer to getting it right, where we ask two questions. How are consumers looking at the world, and has the mark owner done something stupid? And I think we can shift our forfeiture inquiries, naked licensing, abandonment through non-use, in that direction. Do we need to make that shift? I would suggest the answer to that question is yes, for a couple of reasons. When we think about trademarks as source signifiers, when we think about this information transmission theory of trademark law, the trademarks are supposed to be communicating, I think there's a couple of reasons to think the current structure of abandonment through non-use and naked licensing is problematic. First, if you want to call it a property right, we can argue about property, but to the extent we're granting rights to trademark owners to exclude others from the use of these terms in certain contexts, property needs to be communicative. You can look at the work of scholars like Carol Rose and Henry Smith and Bob Ellickson, and what they seem to suggest is it matters not only that I have the right, but that the right I have communicates with other people. So, in Chicago, when it snows, if you want to conserve a parking space, you clear out the space, you've done the shoveling, and you're going to show that you own the shoveling by the chairs. Now, some people respect the signal, some people don't, but by custom it's kind of accreted. Garbage can's not as good a signal because I leave my garbage can on the road every week when I want the garbage man to take away my trash. An interpretive dance would likewise be a bad signal, right? I want a signal, though, that conveys something to you that you understand. We care both what the property owner thinks and how the signal is received. Now, I've spent a lot of time thinking about linguistic theory. Dan Burke stops me in the hall. He says, I love your linguistic theory stuff. I'm looking forward to this paper. I said, you know what? I've only got one slide of linguistic theory. He says, you know what? I'm going to miss your panel anyway. But here's, he's in another room right now presenting, but here's the slide, right? I think trademark law has a lot of similarities with thinking about language change over time. What I mean by that is a trademark owner is trying to cement in our minds that Xerox means photocopiers from the Xerox Corporation. What abandonment and naked licensing seem to suggest is that the primacy of the original innovator really, really matters. And the way language change usually works is if the initial innovator is the only person that matters, we call that a nonce formation. In other words, it's a change that doesn't stick and nobody cares about it. Sometimes uses can become contextual, sometimes they become standard, but that standardization, that depends on everybody else in the system. And our current abandonment and naked licensing regimes are presuming away the role of everybody else. I think there's a potential pernicious effect if that trickles into, say, for example, acquisition or infringement inquiries. Then we start having a fight between two mark owners and we ignore consumers entirely. That can't be I mean, you could tell me in question and answer why that's the right answer. That strikes me as it's got to be the wrong answer. Finally, it's not clear from a policy standpoint whether a world in which Pepsi's got to keep bringing out Slice every 3 years is better than a world in which Pepsi can pull Slice, bring it back in 20 years. I'm not sure which world is empirically better. The presumption right now is, abandonment through non-use. The Pepsi's got to keep pushing it out there or we're all just going to forget it. I think that's probably empirically falsifiable. We may want to ask that question. All right, so what do we do? If I'm right, what do? We could change the nature of the inquiry. We could do the modification move, which is to just ask, rather than presume, at least for courts to engage in the mental exercise. Are consumers really going to be confused by this particular type of naked licensing? Is there a consistency of product between Eva's Bridal of Oak Lawn and Eva's Bridal of Oakton? We could look for survey evidence. Should we pick the 50.1% number? I don't know. But we could try to find an anchoring number. We could ask consumers if they see this mark as continuing to hold some residual goodwill. We could engage in a more generalized inquiry. Here I'm thinking some mechanical Turk type mechanism where we reach out and we say, we give you a hypothetical and we say, Store A licenses to Store B and doesn't check up on Store B. Are you likely to be confused whether these are the same store from the same source or not? And this is just kind of off the cuff. You'd have to be a little more careful about this. Maybe that generalized inquiry could tell us some things about how consumers see the world. There's a potential danger here, though, which is if we shift the point at which a mark is abandoned into the public domain, and especially if you're worried about impoverishment of the public domain, this is giving trademark owners more control in a time where a lot of IP scholars think trademark owners have too much control as it is. Is there something else we could do? Perhaps, I think maybe, something more like a liability rule. And what I mean by that is this. Invite courts to look for evidence of residual goodwill, figure out how to quantify it, kind of like a reasonable royalty remedy, where we're trying to figure out what's the value of the goodwill in the minds of consumers, and the new appropriator has got to pay the original mark owner that value. It's a liability rule as opposed to a property owner. We don't let the trademark owner stop them from entering. We don't let the trademark owner stop them from appropriating the mark. But we do try to make it more expensive in those cases where the largest amount of residual goodwill is still around. And the reason for that is to provide some sort of valuation for that residual goodwill. That's the goal. Now, I have some thoughts that I'll talk about in Q&A if you want to about how you do that, what you make it look like. We could ask about, has the mark owner licensed in the past? We could engage in inquiries about the strength of the mark. We could ask competitive questions. Does the new product really conflict with the old product in ways that bother us? Has the mark owner done stupid things we don't like? These are kind of some of the moving parts in my mental image of how this inquiry would work. But I think the value of it is we don't provide the mark owner with the ability to stop new entrants, but we do provide some valuation of the residual goodwill in the hands of consumers. Now there's one obvious problem with this is a better world might be where we're finding a way to compensate consumers directly for the harm, but we've never done that in trademark law. We're always talking about consumer confusion and we're always giving the mark owner the benefit of kind of enforcing that consumer confusion. This wouldn't be much different. But if the reasonable royalty is calculated correctly, it will slow down reappropriation in those cases where there's most likely to be the largest amount of harm because there's the largest amount of remaining residual goodwill. So, that's kind of a shotgun approach drinking from a fire hose, but I'm looking forward to your thoughts on the project. Mike?
So, this seems to present, right now we have something of a rule, right? It's very easy to lose rights and we don't have to do deep inquiries, right? And so obviously your approach introduces the problem of factual assessment. And so that requires us to have some sense of the rough empirics, which I don't know any better.
Right.
I mean, I certainly know less than you do. So it seems one reason to think that your proposal is good is that the kind of marks that people will be reappropriating are the kinds that have residual goodwill, and they'll be worth fighting over, and that's what. Okay. But it seems on the other side, right, is that if you have a mechanism that every time a trademark holder abandons, in the traditional sense, his or her mark, that they can then emerge from the woodwork and demand something, you now have the potential for trolling. And I was wondering if you might there be a mechanism where if you want to reassert your rights, there's some sort of threshold level. You've got to pay this much and then you collect your royalties. Right?
So, I kind of like that, actually. So is there a way we could get a credible signal where we're retaining certain rights? It's got to be less than kind of a full-on ad campaign, and we don't get any of the potential benefits of the project. But in a way, it's kind of like Landis and Posner's suggestion that what we really ought to do with copyright registration is it ought to be perpetual, and the amount ought to just rise every year. I hadn't thought about that. The trolling problem I do worry about. I'm honestly more worried about trolling in the case of live marks. And I think the trolling problem is a little different because of the potential harm to consumers in a way where I don't think copyright or patent trolling has the same sort of harm to consumers with the reappropriation that it does in the trademark context. But I am seriously thinking about it. But I like your addition there. Okay, please.
Very interesting presentation, and I wonder whether you could also consider perhaps the European perspective on this issue. In particular, thinking about the Kornspitz case, which came to the Court of Justice from Austria. Kornspitz was actually registered in connection with flour.
Okay.
And that flour was actually supplied to bakers, and bakers actually made, I think it was some sort of pastry. But when the consumers actually got the pastry, they actually came to know this pastry as a Kornspitz.
A Kornspitz?
Yes.
Okay.
Yeah, it's called Kornspitz. I think it's Kornspitz.
Okay.
And a competitor of the flour producer applied for revocation. His argument being that the end consumers of pastry had actually come to perceive this name as a generic name.
Right.
So it had actually lost its distinctive character.
Mm-hmm.
The way we approach questions in Europe from registration purposes, i.e. distinctiveness, the scope of protection, and even the potential loss of rights is through the eyes of the consumer. So apart from having those subjective questions regarding the inactivity of the proprietor,
right.
A key aspect here would be the perception of the consumer. So we don't actually look into issues like residual goodwill.
Mm-hmm.
We actually ground the whole assessment through them. And interestingly enough, even recently, the court has also ruled that when a particular trademark is used in a slightly different way from which it was actually registered originally, if the consumer still perceives that trademark as relating to the trademark, the original trademark, think about Specsavers, which is a trade in the UK, that they sell specs and they use this green logo. But they originally registered the logo in monochrome, so it was actually black.
Mm-hmm.
But through intensive use, consumers in the UK came to understand Specsavers just by looking at the logo. So they were able to preserve those rights in connection with the green colour, and same happened to the
because of
rights,
usage
etc.
rights.
So you may want to perhaps, there are some European lessons here
Well,
from American law.
And I think you're right. I mean, that's why I thought, the survey we do in generis-like cases in the U.S., where we're looking for the 50.1% preponderance, that's the kind of inquiry I want to add to this. When we talk about strength or value of the mark, both inherent and acquired, that would be, building in that sort of an inquiry. I think that's exactly right. Laura?
So this will highlight some things we talked about before, but I guess I would encourage you to connect more the proposal for royalty with sort of the end game or what's driving, what's underlying the problem here, right? So if the former mark holder, for example, has no intent of re-entering the market, is that a predicate for this, that the former mark holder has the intent of re-entering the market?
The way the current test works is 3 years prima facie loss. I can rebut that by saying I've got an intent, I intend to re-enter, and it's got to be something more than just saying.
But even your proposal would require that. So it's not simply the idea that this is, because of residual goodwill, there's confusion created here, and so therefore we want to create some sort of compensatory scheme to dissuade the new entrant from taking advantage of that residual goodwill, whether or not the original producer has the intent to enter the market.
And here I'm a little unsure here, and let me tell you why. I think it is right to ask things of the mark owner like we do in abandonment inquiries, like we do in naked licensing inquiries. That's all we're doing right now. But I am worried about a situation, and I think from your hyper, you can imagine a situation where, look, Pepsi doesn't really intend to bring Slice back, but somebody else picking up Slice does cause real harm to consumers. Mm-hmm. The reasonable royalty mechanism is designed to slow that down. If there is, a large measurable cohort of injured consumers, the new entrant's got to pay the old mark owner for the difference. Now, I get that that's a payment to the mark owners opposed to the consumers. If you've calibrated the remedy right, what that'll do is slow down reappropriation in the cases where it's most harmful. And that's why I'm on the fence about it. It's not entirely clear to me that the mark owner's perception, the mark owner's intention about reusing the mark or not, changes the consumer position. But there's a really interesting case where there's a, I can't think of the name because I never lived in LA, but there's a taco stand in LA that I want to say Taco Time bought them out, or one of those taco chains bought them out, and everybody loves them. Somebody else has kind of tried to find the old recipes and is restarting, has now been sued by Taco Time. This is a tough spot, right? Because, look, the corporate entity is not giving consumers what they want. They want this old taco shop. If the guy's really upfront about the fact that he's not the old taco shop and he's trying to bring back that vibe, that strikes me as a good reappropriation. There's some value here. It's not clear to me that Taco Time's in a position to exploit it. So that's a tough case that I'm still on the fence what to do about. But I think your critique is right on.
Well, and also I think linking, why if there is confusion caused by the residual goodwill, why sort of what you're calling a royalty payment addresses sort of that harm. Because, as we talked about before, if you've got a defendant who can easily absorb that cost,
right,
then, all you're doing is just doing kind of a wealth transfer from one party to another, leaving all this confusion on the table.
Right, and
and
I'm still thinking about that part. And I'm resisting right now giving more injunctive relief because I'm worried about the broadening of the scope of protection. But you're right that there is some harm left. I think we've got time for one more short question.
Okay, I think that harm is often a straw man in trademark law, and I think you're assuming that there is in fact harm for parties taking advantage of residual goodwill. Just because they're profiting from it doesn't mean there's harm to consumers. And in fact, companies and brands are transferred and licensed so often in the real world that the actual control is irrelevant to consumers. The product flavor and composition changes slightly all the time. So actually, it's the same problem with your linguistic analysis. Linguistics assumes a synchronically static state of language, not one that can be gained by actors who, once told the rules, can change the language and the language actors accordingly. And that's my general concern, that your theory would work if parties couldn't respond strategically to it, but they're going to do precisely what people have said, which is they're going to jump out of the woodwork, they're going to claim they did have an intent, they're going to rent seek. It's not going to protect consumers from any harm that we actually care about, and it's going to impoverish the public domain, which, as Jeannie and Barton have shown, is a real concern in the word mark context. Right, yesterday there was a talk about
that was there.
phonoaesthetic marks also,
I missed
and
the phonoaesthetic
slice
mark.
is one of those, right? You can only have so many combinations of words that sound like a refreshing drink, right? So this is my general concern.
Right.
Is the presumption of static words.
And I'd like to talk more about that, but I'm out of time. I have to shut up now. So let's talk over lunch, maybe.